Mute.
Our documents. I have to find a good way. This follow. This is a record. We have to find a good way. I want me to set it. But I know about it.
After considering the submissions of counsel for the parties on jurisdiction, I am of the view that this is an appropriate case in which reference should be made pursuant to Section 295 of the Constitution to the Court of Appeal for guidance on the issue of law which arises as a result of the decision in the recent case of the Supreme Court in the case of Elegbe versus HP International School and others, and the earlier case and the earlier decision of the Court of Appeal in suit number CA/C/7/2016, decided on 16th day of July 2021. In view of the foregoing, I hereby state a case to the Court of Appeal for its consideration and guidance. In the circumstances, this case is hereby adjourned sine die pending the outcome of the case stated. Call the next case. Registrar,
Suit
call
number.
the next case.
Yes, my lord. Suit number NICN CA12-2026 between Union of Tipper and Quarry Employers of Nigeria and one Stephen Asanga Eso, two Desmond Eyonga Nso, three Basin Ndifon Iyam, for themselves and on behalf of persons operating under the name and style of Ecom Sand and Gravel Dredging and Trade Tipper Union. My lord, the parties are absent.
Appearance. Appearance. Appearance.
My lord, profound respect. Yes, or damn, humbly announce. S, my lord, is initial, or damn, Ijoma. Announce my humble appearance, my lord,
Yes.
for the respondents. We apologize their absence.
Yes, any other appearance?
May it please my lord. My name is Benjamin Edet. My appearance is for the applicant.
This matter is for judgment. The judgment is ready. It will be read shortly.
As the court pleases.
My lord. My lord, I'm sorry. I was in the last matter. And I have
Counsel, I can't hear you. Your network is bad.
Even when my lord was reading the judgment network issue I have on my end here. My Lord, I'm referring to the last judgment you read. Very well,
Yes.
my Lord. I'm only saying that I was in the last matter in which you just delivered judgment. That even when I came on, the audio was bad. I could barely hear my Lord here. And at the point, I was equally disconnected from my end.
It is the fault
So
of your network.
bring it to the attention of
Counsel, I can't hear you. I can't hear you. Your network is not
my
good.
end too, because I could barely hear my even when I came
Yes,
on.
if you know you have
I'm
a virtual
referring to
sitting,
the one
you must
just
be
read
a
the
place
judgment.
where there is good network. Please, counsel. If you have a virtual sitting, you must ensure that you have a good network.
Very well, my Lord. Very well, my Lord. If my appearance can still be taken.
I can't take your appearance. I have already called another case.
In my office here before
I have
you
already closed that case. I said I can't take your appearance now. I can't take your appearance. When I call for appearance, you refuse to announce your appearance. Yes, this matter is for judgment. This is the judgment of the court. This deal with originating summons dated 31st day of March 2026 and filed on the same date. The originating summons was brought pursuant to section 254, subsection 1A, B, J, and 6 of the Constitution of the Federal Republic of Nigeria 1999 as amended. Section 1, subsection 3C, subsection 2(1), and subsection 32 of Trade Unions Act as amended, and Order 3, Rule 3, and Rule 16, Sub-Rule 1 of the National Industrial Code Civil Procedure Rules 2017, Rule 5, Sub-Rule 3 of the Union of Tipper Query Employers of Nigeria Constitution 2022 as amended, and under the inherent jurisdiction of the court. In the originating summons, the claimant submitted 5 questions for resolution. The 5 questions have been captured in the body of the judgment, so I will skip reading them. In anticipation of the favorable resolution of the questions posed for resolution, the claimant seeks for the relief stated as follows. I will also skip reading the reliefs. Counsel, when they get the hard copy, they will see the reliefs there. The grounds for seeking the reliefs also for bringing this originating summons for interpretation have also been reproduced in the body of the judgment. I will also skip reading it. Benjamin Edet Esquire, counsel for the applicant, in arguing in support of the originating summons, informed the court that the applicant has accompanied the originating summons with a 24 paragraphs affidavit with 5 annexes marked as Exhibit RG1 to RG5 in support of the application. And upon receipt of the defendant's counter affidavit, the applicant has filed a 12 paragraphs further and better affidavit. Counsel relied on the deposition contained in the affidavit. Counsel also adopted the written address file along with the originating summons and the written address file along with the further and better affidavit as his argument. Counsel asked the court to grant the relief sought and discountenance the opposition to the originating summons. In the address file, along with the originating summons, counsel formulated a single issue for resolution, to which, whether having regard to the provisions of Section 1, subsection 3C21 and 32 of the Trade Union Acts, the certificate of registration of the claimant, Rule 5, sub-rule 3 of the Constitution of the claimant union, and the facts before this honorable court, the claimant is is the lawful trade union also right to organize employers engage in quarrying, sand gravel dredging, and tipper haulage operation, and whether the dependents possess any local authority to interfere with the activities of the claimant. In arguing the sole issue, counsel submitted that the claimant is a trade union duly registered under the provision of Trade Union Acts Cap T14 laws of the Federation 2004, and by virtue of Section 2, subsection 1 of the Trade Unions Act as amended, trade union must be duly registered before it can lawfully function as a trade union in Nigeria. The clear implication of this provision is that only trade union duly registered under the Act are recognized by law as having legal capacity to organize, regulate, and represent members within their respective jurisdiction. In support of this, counsel cited the case of Osawe versus Register of Trade Union, where it was held that registration of a trade union confers legal recognition and authority upon such union to operate within the scope of its registered trade or industry. Also, in National Union of Road Transport Workers versus Road Transport Employees Association of Nigeria, the Supreme Court reiterated that the Trade Union Act recognizes only duly registered trade unions and that no other association can lawfully exercise the function reserved for such union. In the instant case, according to the claimant, the claimant has placed before the court the certificate of registration with an approved constitution clearly established its jurisdiction over employers engaged in quarrying, sand dredging, tipper haulage operation. In particular, counsel referred to Rule 5, Sub-Rule 3 of the said constitution. Counsel stated that the above constitution clearly established that the claimant is the recognized and the union responsible to organize and regulate operation within the quarrying and tipper haulage sector, while the dependents, on the other hand, operate under the name and style IPCOM sand gravel dredging and tipper union, which is not registered under Trade Union Act. Counsel submitted that it is settled law that an unregistered association cannot lawfully assume the function of a trade union or exercise regulatory authority over members operating within a sector already covered or recognized union. According to counsel, claimant has clearly established its lawful authority to organize, regulate, quarrying, and dredging. Counsel further argued that by virtue of Section 2541C of the Constitution, as amended, this Honorable Court is vested with exclusive jurisdiction over matters relating to interpretation and application of the Trade Union Act and dispute involving trade union and employers association. This court possesses the requisite jurisdiction to determine the right of the parties to grant necessary injunction as being sought by the claimant. Counsel relied on the case of Akapo versus Hakim, Habib, and others. Counsel continued his submission that in this case, the affidavit evidence before the Honorable Court clearly demonstrated that the defendants have issued directive to members of the claimant, imposed levies on members of the claimant, obstructed dredging operation, and harassed and threatened members of the claimant. These actions amount to a clear and unlawful interference with the statutory rights and jurisdiction of the claimant union. Counsel further argued that the affidavit evidence also revealed that the defendants claim to be operating sand and gravel dredging activities pursuant to a mining lease which they purport to have obtained from the Nigerian Mining Cadastral Office. According to counsel, the implication in the claim is significant. By engaging in sand and gravel dredging operation pursuant to such a mining lease, the defendants have placed themselves squarely within the very industry regulating and organizing the claimant union. Having chosen to operate within the industry, the defendant cannot simultaneously deny regulatory jurisdiction of the claimant. Council submitted that the conduct of the defendant who operate within the industry and organize are regulated by the claimant while purporting to challenge the authority is analogous to a situation where a son attempts to usurp the authority of his father. Such conduct is inherently contradictory and legally untenable. Council submitted that law does not permit the creation of parallel regulatory structure within an industry already governed by duly registered trade union. Council also argued that it is settled law that where there is a threat of continuous interference with a legal right, the court will grant perpetual injunction to restrain such an unlawful act. Council asked the court to uphold the statutory authority of the claimant to restrain the defendant from further interference with the lawful activities of the claimant. In concluding his submission, counsel asked the court counsel contended that the claimant has placed before the court uncontroverted evidence establishing that it is duly registered trade union with jurisdiction over employees engaged in quarry and sand dredging and tipper haulage operation. O.N. Abbo Esquire counsel for the defendant in oral adumberation has informed the court that the defendants have filed a certain paragraphs counter affidavit sworn to by the first defendant. The affidavit has 3 annexes marked as exhibit A, B, C, and A, B, and C. A written address was also filed along with the counter affidavit. A further counter affidavit was also filed in response to the further and better affidavit of the claimant. Counsel relied on the abandonment contained in the affidavit evidence and further counter affidavit. Counsel adopted the written address as his argument. In the written address, 3 issues were formulated for determination, to it whether the respondent, not being member of the applicant trade union, can be made to operate under the supervision of the applicant. Whether the respondent, having been granted a license by the Federal Minister of Mines, in any way in breach of any of the action of the applicant, and the response from the respondent, there is indeed a trade dispute. The counsel for the defendants argued the 3 issues together, starting by submitting that the Trade Union Act itself recognizes freedom of every citizen of Nigeria to join or to refuse to join a trade union, and no Nigerian is to be coerced into joining any trade union. On this contention, counsel relied on Section 1 of the Trade Union Act law of the Federation, Section 1 of the which define a trade union as combination of workers or employers, whether temporary or permanent, the purpose of which is to regulate the terms and conditions and combination in question, defendants as I quoted what the defendant's counsel put in his address as Section 1 of the law, but unfortunately that provision was not correctly quoted. Counsel submitted that the law as amended in 2005 and 2015 emphasized voluntary membership of a trade union, and no employee can be forced to join, be victimized for refusing to join or remain in a union. This position of the law is in tandem with the provisions of Section 40 of the Constitution of the Federal Republic of Nigeria as amended with regard to freedom of association. The Supreme Court of Nigeria gave vent to this provision in the case of Emeka versus Okoropo, the right under Section 40 of the Constitution, the right to assemble and freely associate with other works both ways. The others you want to associate with must be prepared to associate with you. None can be imposed by order of court on the other that of others to freely associate with or disassociate from whosoever. Counsel posited that the respondents are not members of the applicant, but rather members of cooperative society duly granted a small-scale mining license by cadastral office under the provisions of the Nigerian Minerals and Mining Act 2007 as shown in Exhibit B, respondent counter affidavit. Counsel asked the court to Counsel argued that the beaches or area granted the respondent to operate exclusively are clearly stated in Exhibit C of the respondent counter affidavit. In his summation, the Counsel also refers to Section 76 of Section 3 of the Minerals and Mining Act 2007. Counsel submitted that the Act made it abundantly clear as to the purport and implication of mining lease license when it provides in Section 76 of Section 4 as follows. In this section, industrial use includes sale, bargaining, and usage for a connection with any industry or trade, and excludes sand dredging for improvement of navigability of waterways, insofar as the sand dredge is not sold or used for commercial purposes. Counsel submitted that the above provisions of the law illustrate the power and the source of authority of the respondent is excavating and sand gravel in the beaches and areas leased to them by the Nigerian Cadastral Office. The applicant, on the other hand, have no such license as regard respondent beaches in Okuni, in Ikom local government area of Cross River State. The respondents have the authority to control and manage the area of all beaches granted to them by the mining license and lease. According to counsel, if the members of the applicant union operate within their own approved cadastral area, of course, the respondent will not have any authority over them. Likewise, the applicant will not have any authority over the respondents who are operating within their approved beaches or areas. According to counsel, the course of action as anchored on the applicant registration as a trade union is actionable only against applicant members and not respondents who are not members of the applicant. There is no dispute as such as defined by Section 47 of the Trade Dispute Act as construed in the case of Akabwe versus Ugwebian Local Government Area Council. In concluding his submission, counsel found that the respondents are not a trade union or under the auspices of the applicant, as they are not members of the applicant, as there is freedom to associate even as regard trade union, and no trade union can compel any citizen of Nigeria to belong to such trade union. Respondents, as a registered cooperative society, is licensed by the Ministry of Mines and Power to operate business of sand gravel dredging within the approved beaches and areas in Okuni in Ikom local government area. The respondents are not interfering with any member of the applicants in the beaches. The business of quarrying and sand dredging is open to all qualified Nigerians and registered cooperative society who are licensed. According to counsel, the applicant suit has raised substantial issue and dispute of facts that require the filing of pleading as per Order 3, Rule 1772 of the National Industrial Code Civil Procedure Rules 2017. The claimant filed a 15 paragraphs further and better affidavit in response to the defendant's counter affidavit. A reply on point of law was also filed along with the further and better affidavit. In the reply on point of law, 4 issues were formulated for determination. I have captured the 4 issues and the argument. I will skip reading the 4 issues and argument. I will go to the decision of the court. I have carefully and painstakingly considered the originating summons commencing this suit, the counter affidavit filed by the counsel for the respondents, further and better affidavit, as well as further and better counter affidavit. I have equally considered the written and oral submissions of counsel for the parties. I note from the processes filed by counsel for the parties, applicant was at times referred to as claimant. In this judgment, applicant will be referred to as the claimant, and the respondent will be referred to as the defendants. From the affidavit evidence and submissions of counsel for the parties, both have raised objection to each other's processes. It behoves on me to quickly to resolve the objections of the counsel to the process of each other. First, the counsel for the defendants has argued that the course of action was anchored on claimant registration as a trade union, and this is actionable only against claimant members and not dependents who are not members of the claimant. According to counsel, there is no dispute as such as defined in Section 47 of the Trade Dispute as construed in the case of Kabwe versus Igwebe Local Government Council. In his reaction, counsel for the claimant submitted that the defendant's submissions that this court lacked jurisdiction to entertain this suit on the ground that it does not constitute a trade union dispute, or because the defendants are not members of the claimant, is misconceived, erroneous, and wholly unsustainable in law. Counsel submitted that the jurisdiction of this court under Section 254C is not restricted to dispute between members of a trade union. Rather, this court has broad, expansive jurisdiction over labor and employment matters, including dispute relating to trade union administration, trade unions activities, and the interpretation and application of the constitution of a trade union. In this suit, the claimant is seeking for interpretation of statutory and constitutional scope of jurisdiction of duly registered trade union under the Trade Union Act, as well as determination of legality of the Dependents Act in relation thereto. The dependents are operating under the name and style of ICOM, Sand Gravel Tipper Union, and engaging in acts of regulation, ticketing, levy collection, operational control, and interference with the industry. They have unmistakably brought themselves within the ambit of the dispute concerning trade union jurisdiction function. The operational boundaries of the claimant. Counsel asked the court to discountenance the submissions of defendant and hold that the dispute is within the jurisdiction of this honorable court and grant relief sought by the claimant. Jurisdiction is fundamental in every adjudication, as it is the first gate through which every case must pass. To proceed without jurisdiction is to build a house on sand. The entire judicial edifice collapses. Thus, jurisdiction is a threshold matter. It is very fundamental, as it goes to the competence of the court to hear and determine the suit. For where a court does not have jurisdiction to hear a matter, the entire proceeding, no matter how well conducted and decided, would amount to a nullity. It is thus mandatory for the court to decide issue of jurisdiction before proceeding to consider any matter. See the case of Bronic Motors Nigeria Limited versus Wemaban. See also Okoya versus Santili. See also Madukolo versus Kendele. See also Pabumi versus versus University of Ibadan. Although it is highly desirable and in the interest of justice to raise issue of jurisdiction at the earliest opportunity, usually before trial commences, as to save time and cost and to avoid a trial in nullity. The importance of jurisdiction is the reason why it can be raised at any stage of the case, be it a trial on appeal to this court or to the apex court by any of the parties. A fortiori, the court can so motu raise it. However, once it is apparent to any party that the court may not have jurisdiction, it can be raised even by boss. See the case of Owoniboye Technical Services Limited versus John Holt Limited. See also the case of Kado versus CBN. See also the case of PE Limited versus Leventis Trade Company Limited. The law is settled that a court will have for it if the subject matter is within the jurisdiction. The court from exercising its jurisdiction and the case comes before the court having been initiated by due process of law upon fulfillment of any condition precedent to the exercise of court jurisdiction. See the case of ASEAN versus ASEAN. See also the case of Equity Bank of Nigeria versus Haliko Nigeria Limited. See also Elube versus Omokape. See also Madukolo versus Inkendilim. The law is right that court will not have the necessary competence to hear and determine a matter placed before it if the subject matter lies within its did not lie within its jurisdiction. Therefore, to see whether this court has jurisdiction to hear and determine this suit, reference will be made to Section 254C1A of the Constitution as amended, as which I am trying to find out from it appears this issue of jurisdiction, I treated it in two places. So I want to merge them together in one place.
As a court,
so
please.
as to avoid I know I have, like, toward the end, I have also made mention of that. So I'm looking at it to see if I can merge it with the preliminary points, or I should leave it there. It's here. Yes, Yes, let me see. Yes, let me. I have now merged the by virtue of section 7, section 3 of the National Industrial Code Act 2006, the jurisdiction of the National Industrial Code dispute is appellate and not original. Any suit that is for trade dispute, as defined by Section 48 of the Trade Dispute Act, must undergo the process of Part 1 of the Trade Dispute Act. Therefore, intervention of this court will depend on exhausting the processes of Part 1 of the Trade Dispute Act. The term Trade Dispute Act has been statutorily defined by Section 46 of the Trade Dispute Act that trade dispute means any dispute between employers and workers or between workers and workers which is connected with employment and physical condition of work of any person. The above quoted provisions of Trade Dispute Act have been interpreted by the Supreme Court in the case of National Union of Electricity Employees and another versus Bureau of Public Enterprises. It also in the case of National Union of Road Transport Workers versus Obodo. Applying the dictum in the above decision to the facts of this suit, which is for interpretation of jurisdiction scope of the claimants out any pair of contradiction, that a careful perusal of the originating summons commencing this suit and the affidavit in support will reveal that the claimant's action is not one that is within the purview of Section 48 of the Trade Dispute Act as being claimed by the defendant. The action is seeking for interpretation of certain provisions of trade union acts, trade union and constitutional provisions as they relate to issue of jurisdictional scope and membership of trade union. And membership of the claimant. See also section 2541 ABJ 6 of the Constitution as amended. Therefore, it is clear as the daylight that the dispute before the court is not one that is caught by the provision of Section 48 of the Trade Dispute Act, which would have made the provision of Section 7, subsection 3 of the National Industrial Code Act to become applicable and divest this code of its original jurisdiction. The reason being that it is not dispute between employer and employees or between workers and workers. It is also not in relation to terms of employment of workers. This also means that the dispute is not one that can be situated within the collective labor dispute as the defendant wants the court to believe. The law is right that a court will have necessary competence to hear determine a matter placed before it if the subject matter of the law fall within the jurisdiction of the court. Therefore, to see whether this court has jurisdiction to hear and determine this case, reference will be made to section 2541A and D and J 6 of the Constitution, which I have quoted the relevant provisions of the Constitution, so I will not read them. The impact of the prescription in the above provisions of the Constitution is that in any civil cause or matter relating to or connected with any labor, employment, trade union, industrial relation, and matters arising from the workplace, the condition of service, including health and safety, welfare of labor, employee, worker, and other matters incidental thereto, or connected therewith, as well as relating to determination of any question as to interpretation and application of the trade union constitution, the constitution of an association of employers, or any other association related to employment, labor, industrial relation, or to deal with them. See the case of Abia State Independent National Electoral Commission by Chief Okechi Kanu and others. See also the case of SCC Nigeria Limited versus George. See also the case of Uti versus Onibio. See also the case of Abdulkarim versus Inka Nigeria Limited and General Electric International Operation Nigeria Limited versus Q Oil and Gas Services Limited. See also Ladan versus Joseph, and also the case of SCC Nigeria Limited versus Joseph. The well-founded principles of law is that in determining whether court has jurisdiction or not to try a matter placed before it, such a court must examine the nature of the claim. See Ademi and others versus Opeyori. See also the WSL Limited versus Iron and Steel Workers Union of Nigeria. See also Oduku versus Government of Ebonyi State. See also Obi versus ANIC. It is well settled on the authorities that it is the claimant's claim that determines the jurisdiction of the court. See Anya versus EIE. See also Attorney General of Kwara State versus Wara. See also Aniboro versus C-Trucks Nigeria Limited and Onora versus Okeke. In the case at hand, it is the affidavit and the relief sought by the court that will determine the jurisdiction of the court. See the case of SCC Nigeria Limited versus George. In line with the above tried position of the law, a careful perusal of the reliefs being sought as per the originating summons commencing this suit, as well as the claimant's affidavit in support, it reveals that the claimant is seeking for interpretation of statutory and constitutional provisions on jurisdictional scope and membership of trade union in the circumstances and legality and determining legality of the defendants act in relation thereto, who are acting and operating under the name and style of Ecomsan Gravel Steeper Union MPCS and engaging in acts of regulation operational control, and Interpol 1CJ6 of the Constitution as amended, the dispute regarding jurisdictional scope of the claimant is within the purview of the subject matter of jurisdiction of this court as encapsulated in the provision stated above. The next preliminary issue has the requisite jurisdiction to entertain and determine this suit. I so found and hold. The next preliminary issue to be dealt with is the submission of counsel for the claimant that the defendants have abandoned the questions submitted by the claimant for resolution and focus their attention on the issues that are not connected with the originating summons. It has raised substantial issues of dispute of facts that require the filing of pleadings as per Order 3, Rule 17, Sub-Rule 2 of the National Industrial Code Civil Procedure Rules 2017. Order 3 of the rules of this code is very clear and unambiguous. By the rules of code, originating summons can be resorted to where the party is seeking for interpretation of the constitutional provisions of any statute, law, or document. It can also be employed by a litigant for the purposes of ventilating his grievances before the court based on facts that are not notoriously contentious or disputed. See Order 3, Rules 16 and 17 of the rules of this court. It is apparent from the provisions of Order 3 of the rules of this court that originating summons is best suited for cases where there are no substantial dispute of fact. Originating summons should only be applicable in circumstances where there is no dispute on the question of facts or even the likelihood of such dispute, or for the situation requiring interpretation, where it is obvious from the state of the affidavit that there should be an air of friction in the proceedings, then an originating summons should be used only where fact, even where the facts are not in dispute, the whole style. See the case of SCC or Ilebe. See also the case of Sani versus Kogo, Kogi State House of Assembly. See also as pointed out earlier, generally originating summons used for non-contentious action. That is, those actions where facts are not likely to be in dispute, where facts are in dispute or directly so, and originating summons will not lie in favor of the claimant where the proceedings are hostile in the sense of violence dispute. See the case of Monaco versus Adeleke. See whether or not a suit was rightly commenced by originating summons. The court is not called upon to resolve dispute or facts, but to apply the law as to shows the proceeding will not likely be
Please, but I don't know what to. Me, I'm
by way of originating summons. To my mind, it is inappropriate to commence this action by originating summons that they are not suitable for determination. See also the case of Oswabade versus in an it appears I don't know what is happening with the network. I now turn to the claimant's argument that the defendants have not conversed argument or questions submitted via originating summons for resolution from the deposition contained in the counter affidavit and the further and better affidavit filed by the defendants in opposition to the originating summons, as well as submissions of counsel in opposing the originating summons. The focus by the defendants was on mining license or lease granted to them. The focus was not on the 5 questions submitted by the claimant for resolution. Let me make it clear that the case of the claimant is not questioning the mining license lease granted to the defendant. All that the claimant is contending is that the sand, gravel dredging, and quarrying are part of the jurisdictional scope for which the claimant was established. I must say at this juncture that the claimant is equally guilty of same wrong. He was accusing the defendant questions for resolution. In the written man's originating summons, the claimant formulated only one issue for determination in the address. In the address filed along with the originating summons, it is this single issue that counsel for the claimant argued and not the 5 questions which were submitted or contained in the authorization summons. The failure of both the claimant and the defendant to adhere to the questions submitted by the claimant for answers and formulating different or similar issues to the originally submitted questions is strong. By formulating issues distinct from those submitted in the original summons for determination, it translates to parties abandoning questions in the originating summons, thereby rendering the argument canvassed by them liable to be disregarded by the court to the provision of Order 3, and in particular Rule 16 sub Rule 1 and 2, Rule 17 sub Rule 1A, B, and C of the rules of this court, which reveal that originating summons is one of the process meant for commencement of action before the court for any person claiming to be interested under an enactment, constitutional agreement, or any other written instrument may by originating summons apply to the court for determination of any question of construction arising from the instrument and for declaration of rights of the person interested, insofar as such questions of construction arises from a subject matter over which this court has jurisdiction. Therefore, the interpretative jurisdiction of the court shall all indicate we support to be interpreted. In activating the interpreter, the originating summons contain questions or questions for construction arising under the instrument involved and a declaration of right of the persons interest. The declaration of right depend on the answers to the question formulated for determination. In the application by way of originating summons, a claimant intending to benefit from this time effort-saving procedure of originating summons in Order 3 of the rules of this court must raise the question or questions for determination on which he seeks determination of the court. This means that the real issue placed before the court for adjudication were those raised in the originating summons, and those are the issues this court will have to address. The choice of counsel to formulate different distinct issues is not proper. Where an issue is not properly raised before the court, it has no business whatsoever to deal with it. A court must confine itself to the issues raised by the claimant in the originating summons. In the instant case, it was the questions and the accompanying reliefs or praise that the claimant raised that embody the issues for determination in the action commenced by originating summons. See the case of Shobuede versus Ministry of Land and Housing, WN. See also Obasanya versus Baba Pemi. In view of the foregoing, though it can be argued that on the formulation of the argument, different distinct issues amount to abandonment of the originating summons. This cannot, however, hold water in the circumstances of this case, as this court duty is to resolve dispute on the question submitted in the originating summons. This is because the law governing formulation of issues for ground of appeal is not the same with the formulation of questions for determination in originating summons. Another reason why the formulation and argument of the distinct questions cannot affect the validity of the originating summons is the fact that the written address in support of the originating summons has the same status with final written address in a suit contested by parties. This is because this court is court of first instance, and it is well settled that designed to assist the court to arrive at justice in a case when the facts are straightforward and in the main not in dispute. That's why the court of first instance will be free to dispense with even final addresses. See the case of Gugwa versus Jumo. In the case at hand, parties' decision to formulate issues different from the questions for determination will show that parties opted not to summon. The choice cannot in any way vitiate the originating summons. However, the court's business is to consider the questions formulated in the originating summons and not those issues coined from the questions as per fact deposed in the counter affidavit. In view of all I have been saying above, this suit can appropriately be determined based on the relief sought and the 5 questions submitted for resolution. This is because it is an age-long action is circumscribed by the duty of a claimant, therefore, is to plead or send the relief and adduce evidence to prove same. This means that any issue not coming within the relief sought in it will be discountenanced for being irrelevant and incompetent. See the case of Gabriel RTB versus Cable Metal Nigeria Limited. This also is a pointer to the settled principle of law that a dependent in an to answer the claim to the fact that form is dependent and cannot, without putting up a counterclaim, make a case different from the case put forward by the claimant. It is based on this settled principle of law that I shall restrict my consideration of the issues to the 5 questions formulated and submitted together in the originating summons. The dependent file in opposition to originating summons, I have carefully
Okay, now the Queen Chairman, sir. Okay, that is
No, sir, I'm not sure going to show my video will come up with you.
the I don't know why the network is misbehaving. I have been brought another of the Constitution of the claimant, Exhibit Article 3 and Section 40 of the Constitution. The provisions of the law seeking for interpretations are as follows. I have reproduced the provisions verbatim, so I will skip reading them to save time. The claimant approached this court for interpretation of the above provisions of the law and Constitution as related to the jurisdictional scope of as a trade union and encroachment by the dependent in issuing tickets to its members and imposing levies, harassment and intimidation of the claimant members, and thereby interfering with the statutory rights of the claimant as trade union. In considering a resolution of the question posed for answers, I shall be guided by the tried position of the law that statutes must be interpreted holistically and not in piecemeal. See the case of Buhari versus Obasanjo. Going by the holistic consideration of the provisions of Trade Dispute Act, by Section 1 of the Act, Section 1 of the Act has defined and give meaning to trade union, thus providing legal boundaries from the myriad of associations that may lay claim to be a trade union organization. The section clearly shows that a trade union must be a combination of workers or employers, be purpose must be that of regulating terms of condition of service or workers must not be an unlawful combination by reason of any of its purpose. See the case of CSC versus AUPE. Section 2(1) of the Trade Unions Act seeks to confer on trade union with the legal personality through registration. Once a trade union is registered, it has come alive and can perform the and purposes for which it was formed as far as the constitution and SSOKC versus Attorney General has this to say regarding legal status of a trade union. Council, please, there should be no noise from the background, please. A registered trade union is a legal person, and the birth and deaths of legal persons are determined by the nature, but by law, are not determined by the nature, but by law. They come into existence at the will of the law, and they endure during the pleasure. Their extinction is called dissolution. Let me say here that by virtue of Section 4 of the trade union must have its constitution registered, and the constitution is binding on the union and its members. being based on a grounds of encroachment into the jurisdictional sport is actionable in law, as it is the complaint of violation of the Constitution of the Union. Therefore, the argument of counsel for the defense dispute cannot. It is only a registered trade union that can carry out union activities and functions. Those functions include unionization, collective bargaining, representing members, and regulating terms of employment of its members. This clearly goes to show that the claimant in this case, being a registered trade union, is empowered by law to unionize members that fall within its jurisdictional scope as per Rule 5(3) of Exhibit RG3 is Constitution. Furthermore, the dependents in this case, not being a registered trade union under the Trade Union Act, cannot under any guise undertake the performance of functions that are within the jurisdictional scope of the claimant. This is because the association under which they operate does not have the locus to perform functions of a trade union. Therefore, the ECOM Sand Gravel's Double Union, having been registered under the Cross River State Cooperative Society law and not be registered under Trade Union Act, cannot lawfully perform union's function or usurp the function, as doing so will amount to violation of the law and rendering the action or activities illegal and unlawful. The Cross River State Cooperative Society law, Cap 13 Laws of Cross River State 2004, governs how multipurpose cooperative society operate in the state, and the dependents are not the exception. The members of a registered society full money to easily share loans, buy goods, and to grow businesses in Calabar. Furthermore, under the law, it is government that regulates activities of the cooperative societies through the Ministry of Social Welfare and Community Development in Calabar. The cooperative society is like a crowdfunding club where members pool money, resources together for taking of low interest loans, buy farm supplies in bulk, or save cash security. It is a simple way of community membership to help each other. It is clear from the objectives and function of multipurpose cooperative society law that they are not charged with the responsibility of imposing levies on members of the claimant. By embarking on such venture, the dependents are acting without bias, as their action violates the law establishing the Trade Union Act. Trade unions. The claimant has argued that being a trade union, it has the power to regulate sand gravel dredging in Nigeria. Consequently, the dependent must operate under its guidance and regulation. The dependent on their part have insisted that they are not members of the claimant, cannot be coerced to join the claimant, as they are members of a pre-lay. They are entitled to pre-lay associate as per Section 40 of the Constitution. They also stated that the action of the claimant is incompetent, as there is no trade dispute between the claimant and the dependent. I have already treated the issue of trade dispute. As pointed out earlier, the function of the claimant as it relates to regulation is strictly on terms and conditions of employment of its members and their welfare. It does not extend to regulating quarry industry in Nigeria. Regulating quarry industry is a function of law, and the agencies of government entrusted with such function are not trade union. The function of trade union, the claimant in this case, is to unionize persons who are within the jurisdictional scope as a trade union. Its jurisdictional scope as a trade union, as enshrined in Exhibit RG3 i.e. its constitution. All those operating in quarry, sand, gravel, dredging, tipper, and haulage so fall within the jurisdictional scope of the claimant. So the dependent and their members operating under the name and style Sand Gravel Tipper Union Multipurpose Cooperative Society, if they operate or carry out quarrying and sand gravels dredging, tipper haulage, falls within the jurisdictional scope of the claimant, though the dependent have constitutional right under Section 40 of the Constitution as amended to freely associate in furtherance of their interests, which with any person of their choice. But it must be made clear that the right to freely associate is not absolute or automatic in the sense that it has to be exercised in conformity with other laws. See Section 45, subsection 1 of the Constitution. I have reproduced the provision. I'll skip reading it. It will be right to say that the applicable law to trade union does not provide for sweeping bandwagon membership mechanism. In Nigeria, senior staff are not as automatic bandwagon membership as there is deemed membership, which means that all eligible members within jurisdictional scope are eligible members to belong to the union that was established to unionize members within that jurisdictional scope. The position of the law on voluntariness in relation to union is clear that membership of a trade union is voluntary, incorporating as it were the right to associate or disassociate as the case may be. However, the concept of principle of voluntariness has to be construed along with the provisions of Section 40 and 45 of the Constitution. A combined reading of these constitutional provisions will clearly reveal that freedom to associate or belong to a trade union is not an absolute right. It is qualified right that has to be based it is qualified right that has to be based on protection of workers' interests. See the case of Citroc Nigeria Limited versus Penn, where it was held that the press restricted freedom to join any trade union as a person proposing to join a trade union must show it protects his interests. See also the case of Peresa versus SSGC, where it was held that Trade Union Amendment Act did not repeal or amend or substitute any of the provisions of the third schedule of Part A of Trade Dispute Act. As at today, the right of a worker, the right to decide which union to belong is not absolute, but it must be exercised within the limit of the Trade Union Act. The right can only be exercised in respect of union empowered to operate within a clearly defined jurisdictional scope of the union of his choice. It is clear from the foregoing that a person eligible to become a member of a trade union contract out of his union to which he is jurisdictionally bound to by as a union or association to which he is not a one that covers jurisdictional scope of his work. This means that the dependent in this case cannot hide under the cover of the provision of Section 40 of the Constitution and register under multipurpose cooperative society law so as to circumvent becoming a member of a trade union under which they are to be unionized. If the dependents have chosen not to belong to union belonging to the area of their business, then they must remain without a union as forming an association to compete with trade union amount to infraction of the law. The defendants have copiously made reference to certain provisions of Mining and Minerals Act 2007 and argued that they have right to operate freely based on the license and leases given to them by Ministry of Mining, and the claimant should also go and operate within their own allocated area and not to come within the area allocated to the dependent. By this position, the dependent seems to have misconstrued the case of the claimant. The claimant is not contesting allotment of license or lease to the dependents. What the claimant are contesting is that being a trade union with definite jurisdictional scope, they have the right to unionize members of the dependents who come within the jurisdictional scope of the claimant as a trade union, and that the claimant is also contesting the power of the dependent to issue tickets and collect levies or even suspend trucks drivers and owners from operating. By carrying out these activities, the dependents are interfering with the statutory function and duties of the claimant. The affidavit evidence and exhibit before the court clearly shows that the dependents who have admitted being members of a multipurpose cooperative society and not members of trade union do not have the legal bias to carry out functions of trade union regarding unionization or regulation of terms and conditions of employment or representing the dependent. The dependents also issuing tickets, imposing collective levies, are assuming trade union function. The dependents are not being a registered union. They have no power under the Trade Union Act to act as a union. The imposition collection of levies as union dues ticket is an unlawful act. The mining lease license issued to the dependent does not give power to issue tickets and levies. The issuance of mining license lease only gives right to extract minerals on a specific area. It does not confer regulatory or taxing power over other operators or drivers within the industry. That power belongs to government agencies. Any levy must be backed by law. For the claimant to also has power to regulate terms and conditions of employment as well as welfare of members. The power to levy must be backed by law, local, i.e. that is local government bylaw, state law or federal law. From above exposition of the law, the questions can be answered. The questions submitted by the claimant for answers can be answered as follows. Question 1 is answered in the positive, i.e. claimant being a lawful trade union registered under Trade Union Act is authorized to unionize, regulate terms and conditions of employment, and represent employers and represent its members and operators engaged in quarrying, sand gravel dredging, and tipper haulage operation in Nigeria, including within Ikom local government area of Cross River State. Question 2, the answer to question 2 is in the negative, i.e. the respondent not being in a registered trade union nor registered trade any law in Nigeria with jurisdiction over quarrying, sand gravels, dredging, and tipper haulage operation possesses no any local authority to regulate, interfere with, impose levies on or issue directives to members of question 3, the acts of the defendant interfering with the operation of the members of the claimant within Ikom local government area amount to an unlawful encroachment on the jurisdictional scope of the claimant. 4, the claimant is entitled to grant an injunction restraining the defendants and any other person acting through them from interfering with the character, functions as contained in its constitution. As in its constitution, exhibit RG3. Question 5. the dependent who have obtained mining license from mining ministry from Nigerian Ministry Mining Cadastral Zone are with them eligible to be unionized. In view of the answers to the 5 questions submitted for resolution, I hereby grant reliefs as follows. A declaration is hereby granted that the claimant is the lawful and recognized, authorized trade union authorized to organize, regulate terms and conditions of employment of its members and their welfare. It does not extend to regulating quarrying industry in Nigeria. Regulatory quarry industry is a function of the law, and the agencies of government entrusted with such function and not trade union. The function of a trade union claimant is to unite its members and represent their interest whenever the need arises. Participate members and on behalf of its members in Nigeria and in particular within ICOM local government area of Cross River State. 2. A declaration is hereby granted that the body known as ICOM Sand Gravel Dredging and Tipper Union under which the dependent operates is not a registered trade union and is not recognized under any law in Nigeria as having authority to regulate quarrying, sand gravels dredging, or tipper haulage in Nigeria. Question 6. A declaration is hereby granted that lack lawful authority to interfere with, regulate, impose levies upon, or issue directives to members of the claimant as it relates to jurisdictional scope of the claimant as enshrined in its constitution. 5. An order perpetual injunction is hereby granted restraining the dependents, their agent, officers, servants, privies, or under any other name and style from interfering with the operation of the members of the claimant. An order of injunction is also hereby granted, restraining the dependent from holding themselves out as body entitled to unionize members or persons operating in sand gravels, dredging, or tipper haulage operation who are under jurisdictional scope of the claimant. The facts as disclosed do not support the grant of damages. The facts as disclosed clearly shows that the facts as disclosed by the affidavit evidence and exhibits before the court clearly shows that there is a complaint made to the police regarding the harassment and intimidation of members of the claimant by the defendants. In the circumstances and in view of the fact that this court has not been told whether investigation has been completed or not, this court will not grant any damages. 9. However, the claimant is entitled to cost. Having succeeded, is entitled to cost, which I assess in the sum of 500,000. The defendants are hereby ordered to pay the claimant the sum of 500,000 naira as cost. Before I end this judgment, I wish to put on record that counsel did not sum correctly. There is need for counsel to ensure laws are quoted correctly as they are in the statute books, as wrong quotation may lead to confusion and raise concern about seriousness about handling the matter before the court. I say no more. Judgment is hereby entered accordingly.
As the court pleases.
As the court pleases. Thank you, my lord.
Registrar.
My lord, sir. I'm sorry, my lord. While we commend the court, sir, I want to make a simple, passionate request, and I wish my lord will grant this. This is to the effect that I don't know how soon we can access the judgment, because most aspect of it, due to network, we're not able to currently get what the pronouncement of the court was.
And you will get the judgment. We will get it by tomorrow.
As the court pleases.
As court pleases.
It will be ready by tomorrow.
Grateful.
You may even access
Thank you, my lord.
on our website. Yes, registrar.
As court
Next
pleases.
case.
Yes, my lord. Suit number NICN 2026 between Ikwo, Kumomo, Ntem, Ekpe, and 1, Government of Cross River State, 2, Attorney General of Cross River State, 3, Commissioner for Health, Ministry of Health, Cross River State, and 1, Zenith Bank PLC, 2, United Bank of Africa, 3, Global Bank, 4, First Bank of Nigeria Limited. My lord, the parties are all absent.
Appearance.
Reporting, my lord.
Announce your appearance
Harrison.
while seated. Please announce your appearance while seated.
Thank you, my lord.
Yes.
Thank you, my lord. My lord, Harrison, Ibian, for the judgment creator applicant. Harrison, Ibian. Ibian, my lord, spelled IBIAN.
Judgment creditor for judgment creditor.
Yes, my lord.
Yes, any other appearance? Any other appearance?
My lord,
yes,
my
Mr.
lord.
Harrison. Yes,
my lord.
Mr. Harrison.
My lord, we have a motion. Yes, my lord. We have a motionless party before, my lord, and we are prepared to move it now. Subject to your convenience, my lord.
Yes.
My lord, we have a motion as party dated 10th June 2026 and filed 3rd July 2026, my lord.
Yes.
My lord, respectfully, by a motion which is brought pursuant to section 83 sub 1 and sub 2 of the Sheriff and Civil Process Act, CAP, XC, Laws of Federation of Nigeria, 2004, and Order 51 of the National Industrial Court of Nigeria.
Counsel, before you make progress, Registrar.
Yes, my lord, I'm here.
Hey, you have not given me this case file.
Okay, my lord, I've sent it to you. If you check your phone, I sent it to you. But
No,
I forgot.
you can't. You have to send the file to me. I can't take a squatting motion without having the file.
Yes, my
I
lord.
can't take it because I have to confirm what I'm giving.
Yes, my lord.
Counsel, I'm sorry, I don't have the case file with me. So we can't make any progress.
My lord, we are equally, it's very surprising. We are shocked that the file is not before you. We have done needful on our part. We are surprised that the file is not before you. We have validly filed.
Come back on Friday, 10 o'clock. I will hear you on Friday, 10 o'clock.
As per please, my lord. We are most obliged, my lord. We are most obliged.
This case is hereby adjourned to 17th of July 2026 for continuation of hearing. For hearing of the ex parte motion.
As per please.
Virtually by 10 o'clock.
As per please. We are most obliged, my lord.
Yes, any other matter?
No, that's all, my lord.
Okay. Thank you, counsel, for being with us. We have come to the end of today's proceeding. Thank you very much.
Thank you, my lord.
Thank you, my lord.
Thank you, my lord.
Thank you.